The agenda that I was sent for this meeting was just blank, by the way. I never downloaded
Just
it.
Nick,
So,
Jeff,
I'm just gonna go with the city.
Amanda was required to have a letter, correct?
yeah.
I mean, I would just get it off of.
You are live.
Good afternoon, everyone. With the hour of 5 o'clock having arrived on Monday, June 26, 2023, the meeting for the Public Safety and Licensing Committee is now in session. The first order of business is our call to order, which we've done. Approval of the minutes for the May 30th, 2023 meeting. Is there a motion to approve the minutes?
So moved.
Second. Second. Any questions, comments? Seeing no questions, comments, all in favor, please signify by saying aye.
Aye.
Ayes have it, motion carries. Next item on the agenda today will be item number 0524-23. Communication sponsored by myself, the chair, requesting the appearance of Bernardo, sorry if I mispronounced, Salinas, for a renewal of operator's license, 4th District. Please come forward, please. Your chair's fine. Sir, please raise your right hand. Do you swear to tell the whole truth and nothing but?
Yes, sir.
Thank you. Please proceed. Who wants to go? Question?
So I guess, one of my questions for you, Alder Pete, so this was, I'm sorry, I'm going off the top of my head here without the, hold on, let me pull this up. So that was deferred from our prior meeting,
Yes.
because there were, questions regarding that?
Yes.
Okay. And then from the rest of the committee, do they have any other further questions regarding that?
Say no-show, or is this a, were you here last meeting?
No, no, sir. I was out of town and.
Thank you. So it wasn't, or due to lack of
So I have a couple questions regarding this. So again, the disqualification for this is per guideline number 7, which was, false statement regarding a misdemeanor or felony over the last 10 years. So obviously, as we're looking at, July of 2020, there are several that are, pending there, based on, and perhaps, Attorney New can speak to this, to the Wisconsin state statute as to what I was looking at, the Racine ordinances. For the Racine ordinances, to my opinion, it appears as though the biggest thing we're looking at is the falsifying of information on that application, and then how that affects, so, you know, misdemeanor, second OWI pending, bail jumping, and PIC, that's all pending, which, and again, Attorney New, it appears as though those things would not disqualify this individual to have an operator's license, but the falsification of the application is what we're talking about, correct?
You are correct, Dr. Sebastian. It would just be the false statement, specifically in this case, 2 false statements. He stated that he did not have any conviction and that he did not have any pending charges, and it looks like he does have a pending charges.
I thought it was the traffic one, so that's why I didn't put that. I messed up by, putting, you know, that I did it or whatever, because I thought it was for traffic and not for what I had, you know, for this.
The application specifically says, minus minor traffic disputes, specifically regarding this. Have you filled this form out before, sir?
No.
It's a renewal, so I'd assume it's similar.
That's all. Boss to a letter.
Can I would you bring that forward, please?
Yes, sir.
Thank you. You haven't seen this before. Any other questions while I'm taking a look at this?
I have a question for Attorney New. Being that all these charges appear to be pending, there may be the operating for without a license, that's not something we can hold against anybody as long as they have not been convicted of any of these, correct?
Correct. Those
So that-
specific pending charges
so-
do not disqualify.
Right, thank you.
So then the issue here is the falsification of information is the biggest issue, concern at this point.
How long have you been bartending there?
Like 2 years?
3 years?
Yes, sir.
And have you obtained your license, bartending license prior to those 3 years?
Yes, sir. Yes, ma'am. Sorry.
So, given that this is your third within 3 years of your misdemeanor, operating without a license, you've been able to fill this form out properly with claiming that, correct?
Yes, ma'am.
Okay. Oh, yeah, and that's the one thing that he did say.
Yes, please.
Thank you. So a couple questions for you. I understand, from hearing your response on why you did not check that you had any pending charges, is that
I just didn't think I, like,
needed to do that.
do anything.
I understand that. You know, what's really unfortunate is that, you know, being able to work with alcohol is a privilege.
Yes, ma'am.
And I guess it's the steps we take to make sure that somebody's gonna do their due diligence and to realize the seriousness. And so, one of the things, the form is extremely simple and it's very clear. It is extremely clear. And that makes it very difficult for us because we don't have much to go off of when
Right.
somebody comes in here. And the harm that can be done from over-serving alcohol, that what can happen within the community to the individual. And so one of the things is to make sure that you are thoroughly reading the things that you are putting your name on and signing.
Yes, ma'am.
We don't know you before today, and I think if you've heard from the line of questioning is that what you had would not have disqualified you if you just would have checked yes. You wouldn't even be before us.
I'm sorry, ma'am.
So, I mean, definitely no apology to us. It's very unfortunate. I think the apology, I guess, is more to yourself and maybe to your employer, and even your future within this year period, just depending on what this committee is going to do. These ones are very hard for me just because we have certain things in place. We had to crack down because you would come in and our hearts for you and we're like, okay, let's just give it to them. The next one come in, they don't have a soft demeanor as you. It's just their personality. We're like, you know what? No, we're not going to give it to him. So we needed to have some consistency. That's why these ordinances are in place. And so, we do have a process to still allow you to come before us. I like to stay consistent and be consistent with all the yous that come before us. So, but, you know, please, in the future, read your paperwork. It's gonna save you. Granted, these are things that maybe you didn't want to put down because you're afraid it's going to be a judgment on your character. And that's not why we're asking these questions, right? So, you know, we do our very best to take in the whole situation, and but this is very unfortunate. So we're just going to read this one. I need to pass it around the table as well. Thank you, Chair.
And Mr. Chair, may I ask a
Yes,
question to
please.
Amber and Attorney New? So it specifically says that this letter that he presented today needed to be presented by Thursday of last week, correct? That he just
Was that?
brought us? Is this the one, or is this?
The handwritten one is the one I just gave.
Right.
So because he's disqualified based on the false statement rather than the actual convictions, there's no evidence of rehabilitation. The standard here is whether the committee finds good cause for the false statement. There's nothing written that's required for this particular.
I guess I'm a little confused by that. So it says you're required to submit documentation by 5 p.m. on a Thursday before the committee to show that you're fit to hold those license.
Right, so that letter addresses anything with respect to convictions. I think it probably could be a clearer letter in terms of distinguishing it between being disqualified based on a false statement versus being disqualified based on a particular conviction. So that sentence that you're reading in that letter applies only to conviction. with false statements. There's really nothing in writing that he has to submit. The
Are there any other questions? Yes.
I'm just gonna make a statement, not so much a question. If you remember from past meetings, we've encountered some language barrier on being able to, read through our paperwork that we're asking to fill out. To me, that was good cause. We didn't offer an option in somebody's native language to be able to read it and to fill it out properly. This, to me, it's a bit of negligence. It's a little bit different. You know, we have these ordinances in place. You know, if we are gonna choose to constantly, you know, pay no mind to it, I suppose, if you will, or, not following through on it, I would say then maybe our committee needs to take a look at amending it and striking that from our ordinance altogether.
Thank you, Commissioner. With this particular issue here, are there any other questions or concerns with Mr. Salinas? Seeing no questions or concerns, a motion would be in order at this time.
Motion to approve.
We have a motion. Is there a second? For further comments or questions needed? I have a question for you. I'm still not clear on what was different this year versus prior years.
Well, my boss will always, we just give him an
Yeah.
come in all at once and bring all the paperwork to,
In other words, so you're saying you didn't read it in the past either? You
I did the first time, and then my boss would just submit it, bring them all in, and, you know, we'd sign everything, and then he'd bring them in, and with the payment.
So question for, pardon me, Chair, Attorney New, or Amber, if there's not a second, for the motion, then,
It
motion
dies.
fails.
so at this point, are we receiving a second?
I have another question,
Yes, sir.
because I want to do as best I can to follow our rules we set forth, as well as make sure that you have a fair, meeting, if you will. I guess the question I need answered from you is, why will the committee assume, or why should they assume, that you won't be in the same position next year?
I'm not gonna, will not mess it up again. I'll make sure I read everything and write everything the way it's supposed to be, and not just sign whatever. I apologize for that again, it's not to myself as well for being a dummy. Not being, just, but yes.
Is there, I'll ask again, is there a second? If there's no second, I'll ask our attorney for the,
So the motion fails, Mr. Chair, so at this point, another motion would be in order.
okay, motion fails, so then you've taken the documentation. Okay, so we need another motion then.
Is there another motion?
Then I would like to make a motion to deny, the request and renewal of operator's license, for Mr. Salinas.
Second.
We have a motion and a second. Is there any discussion? Seeing none, all in favor, please signify by saying aye.
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 Motion passes.
Opposed?
You opposed?
Yeah, you gotta say opposed.
Those opposed, I'm sorry, I thought we did. We have one opposed and two ayes, then the motion will pass.
I'll do that.
As long as
For 1 year, he can't reapply, but after the year is up, he can reapply.
sorry, Mr. Salinas. Thank you for coming.
Thank you, sir.
Very sorry.
Yes, have a good afternoon.
Thank you.
Again, very sorry. Okay, next item on the agenda is item number 0525-23, communication sponsored by myself requesting the appearance of Justin Miranda for renewal of an operator's license, First District. Please come forward, Mr. Miranda.
Are you done with that? You want me to have that?
Does anyone from the committee have any, first of all, do you please raise your right hand? Do you swear to tell the whole truth and nothing but the truth? Thank you. Does any committee members have any comments or questions for Mr. Miranda?
It appears as though Mr. Miranda was very forthcoming with his application. He made it clear, that he did receive a second DUI. He has provided, the proper documentation, to support, his case. In this area, I would like to make a motion to approve his operator's license.
Oh, I'd point out also before that we do have a letter, I guess everyone has seen the letter from the employer. Are there any other questions or concerns? If not, we have a motion. Is there a second?
Second for discussion?
Please proceed.
I just wanted to allow the applicant to address us, and if there's anything that you wanted to share.
No. I'm so nervous right now. No, I just wanna get.
Oh, okay, no, that's okay.
Okay, so this is disqualifying, being that it's the second offense, correct?
It's an OWI within the last 2 years, which would disqualify him from operating.
All right, so that is a disqualifier.
We have a motion. Again, is there a second?
I seconded it already, Chair.
I'm sorry. We have a motion and a second. All in favor, please signify by saying aye.
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 Motion carries. Congratulations.
Thank you. Anything I need to do, or?
No, we have a letter.
I think the clerk's office will be in touch
You
with
can
you.
contact the clerk's office tomorrow, and we can get it printed for you probably in the afternoon. You can come pick it up.
Perfect. Thank you.
Thank you.
Thank you.
Item number 0615-23, communication sponsored by myself requesting the appearance of Kayla, and I hope I don't mispronounce the name, Denowisky.
Not present yet.
Okay. So do we need to make a motion to put it aside?
I'll
Motion to defer?
We have a motion to defer. Is there a second?
second.
Motion and a second. All in favor, please signify by saying aye.
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 Ayes have it. Motion passes. Item number 0573-23, communication sponsored by myself requesting the appearance of Alex Wood for a new operator's license, District 3. Thanks for coming in. Please raise your right hand. Do you swear to tell the whole truth and nothing but the truth?
Yes, sir.
Thank you. Questions for the applicant, please?
Sure.
Yes, please.
Do you understand why you're here? No. Oh, that's what I figured. I'm so sorry. When you filled out the application, there's a question on there that asks if you have any pending or past offenses. You click no, or you checked no. And when we do a background check, it just tells us otherwise.
Right, and actually, they're not in, I do not have it. We also have, I believe, one pending charge as well.
And so if you were here from the first, individual was called on our first agenda item, the same thing truly applies. Now, as I understand it, this offense, if you just would have checked yes,
Yeah,
you wouldn't even be before us, because it wouldn't disqualify you for that license. But we do have an ordinance in place that just state if you do falsify the documentation, then it triggers you to have to come before us. And, kind of like what I said to the last gentleman, the first one on the agenda, is this is a measure that we try to take, just to make sure we understand, because it is a privilege to serve alcohol, and a lot of harm can be done with that privilege, from serving or whatever it may be. So we have to try to really do our best at, we are handing these out and doing what we can. I mean, there's very minimal measures that we truly can take, but this is one of them. So I hope, that kind of clarifies why you're here, and then why we are gonna have this discussion and have to be up to vote.
Okay, thanks.
Are there any other questions or concerns from the committee? Seeing no other questions or concerns, I believe a motion would be in order at this time. For item number 061523, is there a motion?
Make a motion to approve.
We have a motion, is there a second? I'll make the second. We have a motion and a second. Any opposed?
Aye.
Aye. Opposed.
We need some legal advice here.
So
It's
the
dead.
motion failed, and
Motion
another
failed.
motion would be in order.
Motion failed, another motion for item number 0615-23. Is there,
Motion to deny.
Second.
any opposed?
Have to ask for a vote now.
Okay.
Have the motion in order, now you have, get a vote.
So there's a motion and a second. If
All
there's no discussion, then there would be all in favor of, and then all.
Is there any discussion? Other comments? If not, all in favor, please signify by saying aye.
Aye.
Any opposed?
Aye.
The ayes have it, motion fails.
Motion-
Motion passes, I'm sorry, very sorry.
Motion of denial.
Motion denied. Item number 0573-23, communication sponsored by myself requesting the appearance of Alexis Wood for a new operator's license, District 3.
We're on item 0622.
620. Could you repeat that, please?
0622, so item right after that one.
Okay, hyphen 62223, sorry about that. Communication sponsored by myself requesting the appearance of Amanda, is it Coleman, for a new operation license, District 1.
Amanda's not here.
Motion to defer,
Second.
is there? All in favor, please signify by saying aye.
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 Ayes have it, motion passes. Item number 063523, communication sponsored by myself requesting the appearance of Marjorie, is it Kadoff?
Yeah.
Thank you, sorry about that, for a renewal operator's license, District 6. Please come forward. Please raise your right hand and tell the whole truth and nothing but the truth.
Yes, sir.
I swear. Okay, I'll start off by asking, do you understand why you're here?
Yes, sir.
Okay, thank you. Does anyone on the commission have any questions?
I'm trying to, I do have questions, and I'm trying to pull up the tab here, because I'm sorry, I did not memorize everything. And thank you for pulling it up for me. Yes, correct, under guideline 7, but I was just trying to find her specifics. So you included, the theft from 27, misdemeanor, and then again, we're looking at an OWI in 2020. And as we keep saying, this is one of the things and this is one of the things I feel as though we're seeing as a theme on this committee, is that anyone that has any alcohol-related charges, they are trying to conveniently leave out of their application, which, again, as we've pointed out, that's not the problem. The problem is the form. How long have you been bartending, Marjorie?
I haven't bartended in quite a while. I'm actually an assistant teacher. This is a summer position that I'm trying to pick up.
Mm-hmm.
So I haven't filled out the form in quite a while. I'm not even going to lie. I just whizzed through it when I came in. I always remember to write down my 07 theft, but for some reason the OWI and I can't even tell why. It just slipped my mind and I didn't even write it down. But I've been bartending on and off for, gotta be 13 years.
So as you say, you slipped that mind, would, checking IDs slip your mind, or checking what time?
No,
These are the type,
Yeah.
but this is, going back to what Alder Caprillion was saying, this is a matter of life safety. The responsibility of having an operator's license is humongous. And just as it is with any sort of officer, you're responsible for people's livelihoods. So breezing through this and forgetting, that you had an OWI, to me, and again, specifically not putting it on this form, to me, but you remember a 2007 misdemeanor theft, which is far longer ago.
Yeah.
That seems kind of odd to me. So that's really my state on it, and I'm gonna be consistent with my voting, for the rest of this session, and for the rest of the, for now on. I mean, we just can't do this anymore, in my opinion.
Any other comments or questions from the commission? Alder Caprillion.
Marjorie, I know you've sat through all the others, so you have kind of heard and you probably felt what was coming. You know, I apologize, it sounds like you have a respectable job and you're still trying to maintain and do for yourself as the time is off for the summer.
Right.
But, you know, being that we do have ordinances in place, it comes down hard because you know your character. We unfortunately do not know your character, and we can take your word, and, which is, you know, it definitely does hold some weight, but, you know, these forms, they become our record, they become the things that speak to the, if you, let's just say, something were to happen, and they're like, well, who gave her a license, right?
Right.
And then it would reflect back on us, and they're seeing these inconsistencies maybe about this board, then we don't have any weight in the water. And, you know, so unfortunately, as Alder Sebastian was saying, you know, consistency is what we have to do. And it may come to you as being unfair, possibly just because you know who you are.
Right.
So, you know, I do apologize that we come as a heavy hand, and unfortunately, government functions in a very black and white, it's a yes or no vote. We don't have that maybe, that gray area. So I just wanted to offer you this piece of humanity, statement, but unfortunately the vote, it seems that that's what it's neglected of that humanity, but I'm hoping the explanation can at least fill in that gray area.
Well, even with the letter from my husband employer, it doesn't help any, he knows the conviction, I don't know why, I just didn't write it down. Probably because I served on it so far ago,
Yeah.
that sometimes I don't even think about it. I served my time and I paid my fines and.
So where that would matter, and I think it was relevant to a question that was asked by, Alder Sebastian, is, if that was the reason you were being disqualified. So let's say you did write it and it was a disqualifying offense, because there are some that we have, and if it was a disqualifying offense, then it's just like the gentleman who was before you, the young lady, he wrote a letter because he had a disqualifying offense, but he did write it on his application. You completely voided writing any, so there was nothing. So even having a letter from the employer, it doesn't work for what we're addressing here today. It's just the absence of it altogether. So I guess it's one of those harder lessons learned, unfortunately. So I don't know if that clarifies a little bit.
Are there any other questions or concerns? Comments? Seeing none, a motion would be in order at this time.
What's the motion on the table right now?
There isn't one.
There isn't.
I'm unfortunately gonna make a motion to deny the application.
All those in favor, please signify by saying aye.
Aye.
Any opposed?
Aye.
Any other comments or questions? If not, the ayes have it.
Thank you.
Thank you.
Thank you.
Item number 0617-23, communication sponsored by myself on a renewal application for massage establishment license, Alexa Spa, at 5110 Morton Avenue. Any questions or comments, or
I'll make a motion to approve.
we have a motion, is there a second?
Second?
All in favor, please signify by saying aye.
Aye.
Ayes have it, there's 0 no's. Item number 0623-23, communication sponsored by myself on behalf of the City of Racine Police Department for the license from premise report, please.
We have another one from
Yep.
Alexa.
You missed the one, Chair.
I'm sorry, which one?
617.
Oh, 617, I'm sorry.
Which one did we do?
We did 617, I
Yeah.
see the one right above it.
Oh, 61620.
Exact same, just different location.
Okay, oh, gotcha. Sorry about that. Item number 0616-23, communication sponsored by myself, submitting a renewal application for a massage establishment license, Relaxa Spa, DBA Relaxa Spa, 4036 6th Street. Same owner, First District.
I move to approve.
Motion, second.
Second?
All in favor, please signify by saying aye.
Aye.
Motion passes. Now we can move to the police report. Item number 0623-23, on behalf of the City of Racine Police Department.
Anybody on Zoom? Oh, there you are. I didn't even see you there.
Yeah, I'm here, I apologize, I am a last minute fill-in,
Oh, that's right.
No problem. Yes, sir.
Anything that pops out or over concern for you?
I was able to read through this briefly, I mean, I guess there's nothing that's overly concerning to me. I can express whatever concerns that you guys have.
Like mostly, almost fights.
Mhm. Are there,
I do have one question.
please,
This is in regards to May 29th at Doobie's Beer Joint. Are you, privy to any detail besides what we're reading?
I mean, I don't know the exact outcome of the call without having the call for service in front of me.
Mm-hmm. I mean, I'm happy to see that a bartender has called, so that's great. Just seeing some Facebook posts that has been showing that that bar has been quite active and certain incidences have gone on and we were not receiving any calls. So I'm happy to see that this one, we do have a bartender calling in. I just didn't know if there was any other details besides just that, but I mean, that's exactly what we would like to see, so I'm happy to see that, but I don't know if this is, the trend that is happening, and, you know, finally, I don't know if there was a straw that broke the camel's back and they decided to call in, or, but again, I guess then the police would know because they weren't called to the other services, so I guess I'm not sure what I'm asking.
Well, no, that's the only one I'm seeing on here
Yeah.
for them, for this report.
And I guess that's kind of my point to this committee too, is that there was a high rate of incidences that we've been seeing, like on Facebook at least, that have not been getting called in. So it's good to see that, but it's one thing that maybe we should be, you know, just mindful of, just in case it becomes a public safety concern.
I have a question along those lines myself. I'm thinking that because of the warm weather, those types of activities are more prevalent in the summertime than they are in winter. So that's a true assumption. So all of them will probably have, many places will have more negative activities because of the weather, more people out.
I guess what I can say is that our call volume is higher in the
Gotcha.
summer. I mean, it's not necessarily specific to fights, it's just calls in general for police services are definitely higher.
Okay. Are there any other questions?
I
Yes.
do have a question, and it goes to, Alder Caprillian's statement, and perhaps this goes with Attorney New, as well. So, given that, you know, obviously being very, active in social media presence, and then also in my own personal line of work, having different access to, let's say, Tavern League, Facebook posts, other bar posts, things like that. How much of that can I take personally with making my decision, perhaps this is an Attorney Litany, question as well, you know, what can we take from other than the information that we are provided from what you give us to put in, our own interpretations from the other sources that we see? So for example, if I knew a bartender that was working at one of those specific instances and had a specific account, and, you know, is that something, you know, is hearsay, this and that, you know, and being heavily involved in that community, you know, am I making my decisions just based on what we're presented here, or but with some of that also news information, Facebook information, other outside knowing information, with this? So I'd like to know some guidance on what that looks like.
Sure, I think that's a great question. It's actually one of the points that we will be addressing in this training that's coming up right
Mhm.
now. If you don't mind, we'll just save that question and kind of address it with the training.
You bet.
and follow up
Sure.
with that way we don't have to go over it again.
Thank
Okay,
you, thank you both. Are there any other questions or concerns about the police report?
Move to receive and file.
Okay, we have a motion
Second.
received, second. All in favor signify by saying aye.
Aye.
Any, no opposed. Motion carries. This concludes the agenda for the Public Safety and Licensing Committee.
There's one more agenda
I'm
item,
sorry.
and then if you read it, I'll.
Requesting any, did I miss something? Item number 0624-23. Requesting any consideration, any formal expression of concern or other actions pursuant to the police report.
Move to receive and file.
Second.
All in favor, please signify by saying aye.
Aye.
All right.
All right.
Ayes have it. Motion carries. The Public Safety and Licensing Committee meeting is officially adjourned.
No,
We have to move to adjourn.
Is there a motion to move to adjourn?
no,
No.
the training is actually part of the.
Oh, so we can't separate them? Okay. It does say training is the next item.
Mr. Chair,
Yes,
Lieutenant Zupke is asking to be excused for the
I'm sorry.
training portion. Lieutenant Zupke is asking to be excused for the training portion.
Yes.
Thank you.
You're welcome.
I think we should go.
I just noticed it when you turned around and, thank you. I hope you didn't get it, but, yeah, I just noticed it and I'm like, probably didn't intend for that.
One of my chefs just put it, been interviewing chefs all day.
Perfect. All right. So Attorney Letney and I will be going over some training topics that we hope will be useful to you. As you know, this is an annual training. This is required every year of the committee. Ideally, it would be done right at the beginning in April when the new committee has been established. So we're a little bit late this year. I know we did one last year, and I know some of you were on that committee, so it may be a little bit newer to some of you, not so new to others. I'm trying, at this point, to cover topics that I think would be relevant at this time. So hopefully this will be helpful, but again, it's not a comprehensive review for everything. But please feel free to interrupt if you have any questions for either Attorney Letney or I. We'll kind of go back and forth here. But the topics that I wanted to kind of go over here on the next slide would include alcohol licensing in brief, some very specific topics on that. And then I wanted to go over some general due process procedures that are not related to alcohol. And then we'll cover some conflicts of interest, the code of ethics, and then lastly, we will go over some legislative updates so that you know what on the pipe from the state legislators. I'll go ahead and start with the next slide. I created this table on here, which gives you a good overview of all the retail licenses that are issued by a municipality. I know it can be a little confusing sometimes with all the big A's, little A's, B's, C's. So if you take a look at the first line there, we have little A's and then big A's. Those are the nicknames. A little A refers to a class A, with the A being in parentheses. A big A refers to a class A with the parentheses around the word class and the letter A. So when you're talking about a little A, you're talking about beer. When you're talking about a big A, if the quotations are around the letter and the word class, we're talking about liquor. So think of A for away. You're thinking about places like convenience stores, grocery stores, liquor stores. They serve alcohol for beer or liquor to be taken, to be consumed away from the premises. That's why it allows for off-premise consumption. When you're talking about the little B's and the big B's, the little B, again, if the quotation is around the letter B, you're talking about beer. If the quotations are around the word class and the letter B, we're talking about liquor. So with a full liquor license, the other nickname for that, in addition to the big B, would be a full liquor license, because you have to have a little b in order to have a big B. Any restaurant that's applying to serve liquor, they also have to have a beer license or apply for a beer license at the same time. The only difference with a reserved Class B license is the fee that the applicant has to pay to the city clerk's office, which, if I remember correctly, is about $15,000 at this time. But otherwise, it allows for the same set of privileges that a regular Class B has. It not only, with Class Bs, it's not only for on-premise consumption, it allows for off-premise consumption. So a certain amount of alcohol can be sold to go, assuming it is hand-capped or sealed or in their original bottles. So there are certain exceptions to that, but that's the general rule. And then with a Class C, yes.
So you're saying that I can go to the local bar and buy a six-pack and take it home?
Theory, yes.
Okay.
With a Class C license, you're talking about wine. Wine for on-premise consumption only. The current law is that it has to be issued to a restaurant. That will likely be changing soon with a new legislative bill that's coming down the pipeline. And then a Class C wine license is only for wineries. Port Brewery, they're allowed to make beer on the premises as well as serve beer on a retail basis. And I'm sure some of you know this already, but Wisconsin has a three-tier system. It's manufacturers, wholesalers, and retailers. So if you're in each of those categories, you can't, in general, be in a different category. If you have a retail premises, you can't also manufacture alcohol, with certain exceptions, such as the Class C wine. So with that being said, I just wanted to go over some of that. One of the biggest issues that we've dealt with lately that I've seen in the last few months has to do with Class B license, or convenience stores and grocery stores applying for a Class B license. So, as I said, most of the time, when you have a Class A license, it's liquor stores, grocery stores, and convenience stores that have these licenses, because they're selling, they want their customers to take it off and to consume elsewhere. Technically, a convenience store, a grocery store, and a liquor store could apply for a Class B license. There's nothing that prevents them from applying for a Class B license. However, there are some things that we should consider. The first thing you should consider, and we can go on to the next slide here, is the quota system. So the state of Wisconsin has a limit on how many Class B licenses each municipality is allowed to give out. So we have a certain number that we can give to bars, to restaurants, to taverns. So in general, you want to save your Class B so that you can give it to those type of facilities. And that, in the past, has been a good reason to not give those type of licenses to convenience stores or grocery stores or liquor stores. I do know that the city of Racine also self-imposes a quota on a Class A license as well. So even though the state doesn't require us to limit or cap the number of Class A's that we have, the city and the common council has said we only want a specific number of beer license and wine, or beer and liquor license to go. So the number is 36 and 24. We can give out to 36 Class A beer license and 24 liquor license, Class A's. So because of that, when there are no Class A's left, you have this issue where convenience stores or grocery stores are applying for Class B if one is available and coming before you. So that's one of the things that you could consider. But keep in mind too, the other one, if Amber moves down a little bit, thank you. The other thing you want to keep in mind is when you are faced with one of these applications is this a good place where you want people to consume? Because remember, if you're granting a Class B license, you're allowing on-premise consumption. And if you're talking about a grocery store or convenience store, and if there's a gas station next door, you really want people to consume on the premises. Basically, do you want a bar at this location? That's something that you should keep in mind. If it's right in the middle of the neighborhood or if it's close to a gas station, maybe take that into consideration. One of the other things too is underage restrictions. So like I said, if you're a grocery store or a convenience store, you can apply for a Class B, but it really severely limits what you can do on a Class B. Because with Class Bs, there's no underage persons on premises without a guardian. So there's no exceptions for a convenience store. If you're a convenience store and you have a Class B license, even if the person is in there to buy other things, they can't be in there without a guardian. And if you're a convenience store or a grocery store, you really don't want to limit your customer base like that. A lot of applicants don't really understand that when they apply. So it's good for the committee to know these things so that if you are faced with an application, you can point it out to the applicants. And I try to usually do this at the neighbors meeting before you even get to the committee level, but that's certainly one of the things that would prohibit their business. The other thing that they should keep in mind too is the restriction on other businesses on premises. Like I said, there are, with Class Bs specifically, you can't have another business unless it's listed as an exception. For example, if you have a gas station, you can't have a Class B and combine it with a gas station. There is no exception for convenience stores and a bar. You can't have a convenience store and have a bar right next to it on the same premises. Those are not exceptions that are in the state statutes. You can't have that. There is an exception, for example, for grocery stores and taverns. So I know you have seen those are permitted, but again, they still have to face the underage restrictions. The other thing to keep in mind too is closing hour restrictions. So with a Class B premises, it has to be closed, as you know, at 2 o'clock on weekdays, 2:30 on weekends. If you're a convenience store and you want to be open 24/7, you have a Class B, you really do have to close. That would, again, severely prohibit what you can do on the premises. So those are just factors that you should keep in mind when you are faced with some of these applications. At this point, we don't have any local ordinance that restrict these type of licenses from coming before the committee, so you will see it from time to time. I try to put notes or have that discussion at the Good Neighbors meeting and kind of highlight it for you when you get to the committee level. But it's good to know for your information. So the bottom line is it's permitted, but it certainly is cumbersome for some types of businesses. It might be best to leave these type of licenses to bars, taverns, restaurants. So the next thing I wanted to cover is the granting of licenses. So with respect to alcohol license, it's a privilege, it's not a right. I know that Alder Cabrerian and Alder Sebastian have touched on this numerous times before. But keep in mind that once a license is granted, it is pretty difficult to take away. In Wisconsin, it's considered a property right once you have an alcohol license. So once you have the alcohol license, in order to take that away, there has to be due process. There has to be a hearing. There has to be a body of decision makers that hears the evidence. There has to be testimony. There has to be arguments from the licensee before you suspend or revoke that license. So it's a pretty long process, and that process in the city of Racine doesn't take place before the committee. It goes before the due process board. Nonetheless, it is certainly, it would be helpful and more prudent for the committee to really scrutinize an application before you grant the license. Much better to figure out exactly what the game plan is, what they're planning to do. I will say that when you have an application before you, if you don't feel that it's detailed enough, if the plan hasn't been worked out, if the application is, here, we're gonna open a bar, we'll kind of figure out as we go along, we don't really have plans to, you know, finish up this side, we don't know where the tables are going to be, we're not sure about our hours, we're not sure about the food, that's an application that you should probably be deferring to give them time to figure it out. Because you want there to be a very concrete application, because once you approve the application, it's approved like it is, like it's given to you. They can't change the application, and you can't make unilateral changes to that application once it's been approved. So oftentimes, I will see an applicant come before the committee and tell the committee something that's different from their license application. Keep in mind that anything that is spoken verbally, any promises that are made are not binding. Okay? What's binding is the application that has been submitted before you and that you are approving. So if they're making major changes to the hours, to the type of operation, to anything like that, defer the application, have them come back, have them put it in writing. It is much easier to enforce something when you have it in writing than to go back later and say, well, you told us this, even though the application doesn't. That's why I always recommend that you have it. Okay. So I wanted to go over the policy guidelines a little bit. I know that we can cover this a lot today. But to give you some background, this is an issue that the committee has dealt with for a long time, going back years and years, probably at least 7 years at least. The problem of, well, when a person has a conviction, or when they make a false statement, what do we do? How do we treat it so that there's uniformity? And for a long time, there was no uniformity. There was, you know, you come before us, you tell us your story, we decide whether or not to give you a license or deny the license. And the committee really came together and said, we want some guidelines that are in writing. That way we can just take a look at it and apply the guidelines. That's what we did with the policy guidelines that you have in your manual. The goal was to write down a specific type of conviction within a specific time frame that disqualifies the person, or stating that a false statement always disqualifies the person. So that when you see it, if it comes before you, that means the person is disqualified. The only question that the committee should be answering at that point with respect to conviction is, have they presented competent evidence of rehabilitation? And with respect to a false statement, is there good cause for the false statement? And the policy guidelines specifically state the good cause for the false statement is not, I forgot, or I didn't know, or I didn't read it, because the committee did hear that numerous times. That specifically is in the guideline. That's not a good. So we have these in place, and if the committee ever wanted to change that, then certainly we can do that. But so long as these policy guidelines are in place, I would definitely recommend that you follow these so that there is uniformity. And I think the committee has done a really good job of that recently. I just wanted to highlight kind of the background of that and where it came from and why it's. Okay, so conditions.
Yeah, I'm gonna go back, sorry, I thought we touched on all of that, and went a little further.
Right, just back one slide. So you also have a handout. I wanted to touch on conditions. So this is rarely used by the community, but I feel that it would be very helpful. So a lot of times I see the committee struggling with, should we grant the license or should we deny the license? It's always an either yes vote or a no vote. It doesn't have to be a yes or a no. It could be a deferral to obtain more information or to get a more concrete plan, or it could be a yes, we approve, but only if, and that's where conditions come in. So you can place reasonable conditions on a license, and again, you have to do this at the initial stage. You can't add a condition once a license has been granted, not unilaterally. So a good example would be, if there's concern about the volume of music from the neighbors, a good compromise might be, we approve the license with the condition that there's no outdoor music after 9 o'clock. Or if there's a problem with garbage being left on the street or glass, a good condition might be, we approve the license so long as there's no glass container permitted on the sidewalk patio, sidewalk cafe. What is not permitted would be something like no hip hop music. That's not reasonable, it's discriminatory, so that's not permitted. So I can't give you an example of everything that would be reasonable or unreasonable. Obviously, it's based on a case-by-case situation, but I wanted to let you know that that is an option, yes.
Question. So if you're looking at new licensing in that regard, so when we're talking about any new business, we don't know what perhaps their caveats could be with, you know, considering they're brand new. So if they were to come up, so let's say they don't come up with renewal, or if they do come up from, because they don't always come up for renewal every year. They do? Every liquor license does? And operating permit does as well?
Yeah.
Even for, like, so let's say if they're just a, like, even food permit?
Pardon?
Even if they're just a, like, a grocery store permit that comes up every year?
Class A, yes, every retail license expires at the end of the year.
Okay, every year, okay,
And
that's,
then at the end of the fiscal year, so June 30th.
okay, so that's my bad. So no matter what, then we would have so we would have that understanding, I'm new here. So we would have that understanding if we were to renew it with those, or then we could put that with the caveat based on the renewal.
You can't do it at renewal time. So at renewal time, you can't suspend or revoke a license unless there are grounds for doing so. You have to add the condition at the beginning, at the initial granting. You can't just add it in the middle at renewal time. Because renewal, yes,
I say, if something does pop up, they've picked stuff up through the clerk's office where they spit it back to us. So every once in a while, we get some spit back to us on renewals, because there's an issue with something that may have popped up.
So I guess I'm confused.
so at renewal time, if there is an issue, for example, with respect to, you know, loitering on the premises, let's say there's consistently issues about 100 or 200 people being out in the street after bar hours, blocking traffic. If you call the applicant in at renewal time and you're discussing the issue, the applicant can agree to a new condition, but it can't be unilaterally imposed by the committee. Now, if the applicant decides that they don't agree with the license, then the choice that the committee has is to suspend or revoke if there is cause to do so.
Calling in for a renewal, as the example you just gave, would that be considered an expression of concern?
It would depend on whether that would be a nuisance property. So one of the causes and the grounds for suspending or revoking a license would be operating a nuisance house. Depends on how many calls there were, if it rises to that level, and again, that would depend on the facts.
Since I've been here, we've never called anybody in at renewal time. Generally, if there's an issue, we bring it up during the year.
Sure.
It's rarely, if ever, done at renewal time. Say that you can, I guess.
Okay.
Answer your question, Alderman Sebastian?
Slightly, but I think I'll learn more as we go through.
Okay. All right, so if you move on to the next slide, Amber, we already talked about the formal expression. Again, this is a system that we came up with to kind of make it a lot more uniform and automatic. It used to be that the committee would vote to suspend or revoke a license, and the committee would then hold the hearing and decide whether to do that. That didn't make a whole lot of sense from a conflict of interest point of view, because the committee usually had formed opinions up to that point already. So the process that we have now is called a formal expression of concern, and the committee just has to call it in every time they see an issue. Like you've done with any time you've seen an incident from the license. So the idea is the first time is a warning, second time within a 6-month period, or third time within a 1-year period. It triggers automatic due process. So when we get to that point, the committee doesn't do anything. They just call the person in, and if it is a formal expression of concern and it's not rescinded, then it goes to the due process board. The due process board then hears the allegations. They determine whether the allegations are true. That's the licensee's opportunity to present evidence, to contest the facts. If the board finds that the allegations have been substantiated, they can decide whether to suspend or to revoke. or suspend for a specific amount, and up to 90 days. So just because there's been 2 strikes in a 6-month period or 3 strikes within a 1-year period, it does not mean that their license will be suspended. It just means that it goes to a hearing for another board to determine. So really, your only job is to make sure that you're staying consistent with calling people in. When you have a call in, if the committee then votes to rescind that formal expression of concern, all that does is negate the work that you've done. Because if you call a licensee in and there was a problem, and the problem has now been resolved, that's great. You can receive and file it and do nothing else, take no other action. But if you rescind it, that doesn't count as a strike. So then when it happens again, you've kind of undone everything that you've done up to that point, and you've taken the automatic system and turned it into this, the system where you kind of control who goes to due process. That was the point of having a system like this, that you don't make that decision. And if it gets to that point, then it goes where it goes. Nothing to do with just So, sorry, I know I'm taking up a lot of time, Scott. I also wanted to say that a lot of times the licensees will come in to the committee and start arguing about the facts of the violations. You know, they didn't do this, they weren't guilty of that. Not fair. That's really not the time or the place for the committee to listen to that. The point of the call-in is to really to identify the issue and to let the licensee know that it's an issue and try to abate the problem going forward. It should be, here's what's happening, here's what we're notified of, how are you going to fix the situation? It's not their time really to present evidence or videos or arguments against what happened. They can do that later when we get to the due process hearing, but it's really not the time to do that in front of the committee. So you can always let the So geographical, I want to move on here to geographical and quota restrictions for Class A premises. So as I stated, the city does impose a certain number of licenses that are permitted for Class A, again, mostly given to convenience stores, liquor stores, gas stations, convenience stores, liquor stores, grocery stores. There's also a geographical restriction that states that a new Class A premises cannot be within 300 feet of a place of worship, a licensed daycare, a school, community center, or other facility predominantly attended by individuals under the age of 21. It can't be within another 1,000 feet of another Class A premises. We don't want to, the city, the idea was we don't want to concentrate all the alcohol establishments. So if you get one of these petitions, and I believe there's one coming down the pipe soon, the process is, if they wanted to exceed either of those quotas, either the number or the geographical limitations, they would submit a petition to the city clerk's office. That petition should identify 2 things. One, whether the proposed establishment will have a greater economic impact on the community than just simply the addition of another tavern or a liquor store or convenience store. And then 2, whether the establishment will benefit the community by substantially improving the tax base. Is making repairs to the building, adding to the building. If they can prove both of those things and the committee is satisfied, you can certainly vote to exceed the petition. It would then go to the Common Council. It would require a 2/3 vote. And these petition hearings do require public notice as well as a public hearing, and includes notice to the surrounding property owners within 5/10 of a mile. About that. Okay. Just a quick reminder that you do have the Public Safety and Licensing Guide that's put together for you. It includes a summary of all the relevant laws with specific to each license that comes before the committee, and then factors that may or may not be considered. There are also templates in there about what sort of questions to ask, which may be helpful if you haven't seen one of those questions before, or if you just are familiar with what you should be looking at. That's always helpful, but it's a work in progress, so if you ever see something that needs to be please let me know. I can do that and get a new one out there. Okay, we'll now move on to the, general due process. So everything that I've just covered so far really has to do with alcohol licensing, but there are a slew of other licenses that go before this committee under Chapter 22. They include cigarette and tobacco, public dance hall license, massage establishments, towing license, secondhand dealers, public passengers, and so anytime, there is grounds for suspending or revoking one of those licenses, it requires a due process hearing, and these would be conducted before the committee. So it would require, an unbiased decision maker. It would require testimony under oath. The licensee would be able to present witnesses and arguments, and make sure that any evidence that's considered would be, things that are presented at the hearing. That goes to your question, Alder Sebastian, and I'm going to hand it off to Attorney Letton here to kind of talk a little bit more about the quasi-judicial role when you have one.
Mind if I stay here?
No, help yourself.
So, the committee and the common council have two primary roles. One of them is legislative. That's kind of what we think about when we think of, something like common council. You're making policy. You're creating ordinances, you're setting the city overseeing budget, a variety of things like that. Legislative function. You also have a quasi-judicial function. It's called quasi-judicial because it's like a judge. So if you were to think about if you were ever involved in a lawsuit, how would you want the judge to behave as to whatever your lawsuit is? You want the judge to make a decision based upon whatever is in court and based on the law, and not based on my friend told me about this thing, or I was out and about and I saw this thing, or I read the newspaper and the newspaper said, and therefore I'm going to make a decision based on whatever the newspaper said. You wouldn't want a judge to do that. You're in a similar position here. One of the things that Attorney Arnn talked about, the property interest, there's a basic constitutional principle in this country. And you really are the guardians of that in some ways. Under the Constitution, no person may be deprived of life, liberty, or property without due process of law. Licenses and a variety of things like that are property rights. So once a person has a license in their hand, it is their property, and they may not be deprived of it unless lawful process, due process, which means they're allowed to defend themselves, and there's an unbiased tribunal that is listening to what they have to say. Frankly, one of the reasons the Due Process Board was created about 8 or 10 years ago, I forget what it was, whenever it was, the years have gone by for me, was because deal with liquor license issues was because committee members would find themselves hearing the reports from police officers, hearing people come in, and they'd say, things like, this is terrible, we can't allow this kind of thing to happen, this place has been causing problems for years, or whatever it is, and then they would sit as the body trying to decide whether or not to revoke or non-renew a license, and they had already made these outward expressions showing their bias. So that's the reason that kind of exists. So in your legislative function, you're setting policy. Quasi-judicial function, you are applying facts to whatever the law is that exists. So there's, I'm going to let you deal with liquor license issues generally and the other licensing issues broadly as they come up over the year. But a couple of other areas that you might think about this, and the way I think about it is zoning. So the Common Council establishes the zoning code. It establishes what kind of uses can be placed in what parts of the city. But if somebody comes to the Plan Commission or the Downtown Design Review Plan Commission, HTC, Planning Heritage Design Commission, and they want a conditional use permit, and maybe there's a zoning code that says a particular kind of business has to have a 50-foot setback from a residence. And were it to come to you and you say, I don't like that 50-foot rule, I think there should be a 200-foot setback. And therefore, I'm not gonna vote for this unless they agree, or we demand they have a 200-foot setback. But the council has already decided the law for that area is 50 foot. So you couldn't change it like that. You're applying facts to the law. Another example, frankly, is the sex offender residency issues. We have an ordinance that says that convicted sex offenders may live in certain parts of the city without asking, but must, if they want to live in different parts of the city, ask permission, and we have a sex offender residency board. So the council has established the ordinance about it. The council couldn't say, well, I don't like the fact that this person lives in an area that we've already said they're allowed to. I want to call it in and tell them they can't do that. So that would be clearly illegal. But that's a kind of the difference. So I would recommend, first of all, if you've got something that's a due process issue, the way you handle these operators' licenses tonight is don't go gathering facts on your own. Only make decisions based upon what the existing law is. And also be careful about public statements, whether they're here or whether they're somewhere else. I mean, I heard this bar is real trouble. A constituent calls you and says, I'm having trouble with this bar. And you say, I agree, it's terrible, we should do something to get rid of it. That's not the kind of thing that you do under your quasi-judicial. If, a resident says, I don't think we should have bars in the city of Racine, I advocate for having an ordinance that says no bars, okay, well, that's the kind of thing you can talk about. Maybe someday you pass that law.
I have a question then regarding that, if you don't mind, unless you had to finish out your thought. Okay. We had, for an example, so we do get the license premise report, and there was nothing on the license premise report. This is gonna go back to a committee maybe prior to when you two were on, but when, Alder Peterson and I, were on, one of the bars in Racine, there was nothing that came up. However, the calls to the alders were heightened, or the calls to elected officials were, and we've had it in a couple locations, even downtown Racine, lots and lots of calls to the alders, which then spurred them coming before us to talk. So I'm a little confused on what was being said, because the only official stuff that we really have to act upon is the license premise report. But we have been going through different individuals, and they've changed over the years on how they, the information that's being presented to us and how it's being presented. So how do you see those two scenarios? Did we act appropriately by responding to the alders, or the uptick in individuals who came? I don't even think it had to do with the license premise report. They must have saw the tavern or something maybe for renewal. I can't remember why it was on, and it just sparked the whole community around the establishment to come and speak on it. So we used that, I think, for our discussion, and then to carry out some further action, maybe by the attorney's office. But is that too long-winded to answer?
Well, can you help me understand the process by which they got there?
So oftentimes, the best place to bring it up, to get it into the record, let's say, is bring it up during the license premise report. During the license premise report, the police officer is there to present you incidents of stuff that has happened or that has taken place since the last meeting. If there's something on there that you want the police department to look at, you can ask the officer. You can say, this is the call that I received. Can you send an officer out there? Can you get me a report or get me more information on it? The officer would then include it in his next license premise report. It would be on the agenda, and it could be discussed at that time. I think when Attorney Letney talks about not using outside information, it's not placing yourself in a position where you're a witness. You're not going out there, you're not gathering evidence and bringing it in and saying, well, I saw this, I was told this, someone showed me the Facebook post that said this. What are you doing about it? That's unfair to the licensee, because they don't have an opportunity to talk to whoever gathered that information. Right? They don't have an opportunity to talk to the witnesses or to cross-examine them, and that's really what we want to avoid. So if you see something in your position, you can certainly ask the question to the licensee or the applicant. You can say, well, are you doing this? Is this an issue? You know, you can ask questions. You just can't make those presumptions and then use it against the licensee without bringing it into the discussion. But I think you can certainly ask the questions and start the discussion and talk to the licensee or the applicant about what we want to do is avoid a situation where you have all these assumptions, and then when you take a vote, the vote is based on everything that you assume to be true, but not based on anything that was discussed at the meeting. Is that fair to say?
Yeah.
And I think we did in the past, because we did see some stuff online, but it was brought up in the exact, so I hear you, the appropriate time is during the licensed premise report time, even if you're not seeing that establishment, but in your official capacity as an alder in your district, however it came to you, bring that up, because I think then we did discuss it then at a further one. So it sounds to me we went through the appropriate steps, yeah.
She answered the question I had, but she continued.
The next slide is yours.
So I just wanted to talk briefly about the code of ethics that exists in state law and by Racine ordinance. So the Racine ordinance largely adopts very similar language as exists in state law, but it actually has a broader application than statute. So in Chapter 19, Section 1959 is what they call the Local Government Official Code of Ethics, which applies specifically as far as municipal officers go to an elective office of the local government or an appointed office, somebody that's a member of the Police and Fire Commission or something. That's a specific term. Open-ended, it doesn't apply specifically. No local public official by state law can use their position to obtain financial gain or anything of substantial value for the private benefit of themselves, their immediate family, or for any organization with they are associated. And I'll talk about the organization in a moment, but themselves is obviously, you know what that means. Immediate family is somebody that essentially depends upon you, either by or by blood. So a grown child actually not an immediate family. Under the Racine ordinances, the Code of Ethics applies pretty much to anybody that does anything for the city of Racine. It's all elected officials, it's all employees, it's all appointed officials, whether they're paid or unpaid. So it even applies to City of Racine volunteers or anybody that sits on any of the various boards, commissions, or authorities that aren't elected officials. So, I mean, it's a really all-inclusive list. Any person holding city elective office, candidates for office it applies to, any person holding any appointed employees, department heads, administrative managers, you pick it, everybody here the code is applicable. So, and it declares that its purpose is to establish the guidelines, the ethical standards for everybody, and determine what is incompatible with city government. And there's also a formal and an informal disclosure requirement for personal interests. All right, so, and I'm going to read because I'm quoting from the statute here. No person is that big list of people I talked about, may offer, or actually, excuse me, it's broader than this. No person may offer or give to any public official, directly or indirectly, and no public official may solicit or accept from any person directly of anything of value under these circumstances. If it could reasonably be expected to influence the public official's vote, official actions, or judgment, or could reasonably be considered as a reward for any official action or inaction on the part of the official. So if somebody doing something for somebody else could be seen, reasonably seen to influence your vote, or as a reward for something you've already done, thank you very much for that vote on this thing, can I have dinner, that kind of thing, that is inappropriate and improper under the ordinance.
May I ask a question on that? Thank you, Attorney Litany, because I know we've had this conversation from, I think the first week that I started, going to, can someone buy me a drink, can I buy them dinner? And you said within reason, and you said, oh, you know, that's a cocktail or dinner, that's not game tickets, that's not this, that's not that.
Sure. Well, so the ordinance defines anything of value. So it says it's any money, property, favor, gift, there's a list of, including but not limited to tickets, passes, lodging, travel, recreational expenses, cash, offered and provided by anybody doing business or interested in doing business. Let me say, it does not include, and I know it's in fine print there, but it doesn't include salary compensation paid by the city. It also doesn't include hospitality extended for a purpose unrelated to public business.
Perfect, thank you.
By any person other than an organization, okay? So if you're out somewhere and somebody says, can I buy you a drink, that's okay, as long as it's not, can I buy you some drinks, and you understand, of course, I'm coming to the council to ask for this thing.
Of course.
You cannot do it, so. It's pretty broad, anything about, and it's a more than de minimis standard, so I mean, if it's something that's worth a couple of bucks, okay, you know, and where's the line between de minimis and not de minimis? It's really hard to say, 'cause it depends on.
Thank you for that clarification.
Let me just see if there's anything else I want to talk about. So a conflict of interest means an act or a failure to act in the discharge of an elected official's duties or place duties that could be reasonably expected to produce or assist in producing substantial economic or personal benefit to such official, his or her family, or to an organization with which he is associated. And I'm going to emphasize that, an organization with which he or she is associated. Occasionally it comes up that we have alders that sit on nonprofit boards, and I think appropriately they'll call me up and say, well, we're giving money to this organization as part of the budget, you know, whatever it is this something I can vote on or not vote on? And depending upon the circumstance, I'll do my best, you know, my best answer. But associated with, in terms of an organization, and I'm going to quote here, means any organization in which an individual or a member of their immediate family is a director, officer, or trustee, or owns or controls, directly or indirectly, at least 10% of the outstanding equity of the business. So, you know, if somebody's a 50-50 partner in a company, that's pretty easy. If there's 500 people, but I got this question with the Wild Root Market. And there were a lot of people that were members of the Wild Root Market because they gave a $100 donation when they were trying to raise it. I don't think that fit this definition. But if they were on the Wild Root board, well, yeah, that's a different thing. But the other thing is if the person is an authorized representative or agent of the business. So imagine somebody works for a construction company, and the construction company wants to bid on. That seems pretty obvious. Mm-hmm. You know, and so the question is that alder that sits on the board of a nonprofit, are they advocating for something? Are they acting on behalf of the organization? Kind of where the line gets drawn. So, you know, my answer in those cases usually is it's never wrong to recuse yourself. Or that there's a perceived conflict of interest. And occasionally I will say to somebody, yeah, I think sometimes people make their own. That associated with sometimes is a difficult target to to understand. So,
Could I go back on that, a little bit? Is there any difference between being appointed in your official capacity and then volunteering, to be on a, joining a nonprofit board?
well, I mean, I think it's something that the city appoints somebody to. That is a part of their duties. If it's an alder that's appointed, let's be specific, if it's an alder that's appointed to sit on the Civic Center Commission or Police and Fire Commission or something like that. And I guess we've had this conversation about the library board.
Mm-hmm.
The library board is a municipally created entity. The library, it's overseen, it's a municipal library. So any alders that are on the library board are there in their capacity as an alder. Which doesn't mean they don't advocate for the library. But it's not a conflict of interest because you're only there because you're there because you are. And the only time the mayor appoints I'm about to say, is when it's something that is created by the city or entered into the city, like the wastewater commission contract with the other counties saying we're gonna have a wastewater. City. I mean, the ethics code is kind of long, so if you ever have specific questions, ask them.
Thank you.
So I just wanted to touch real quickly on the legislative update. So you may have heard that there's a bill that's pending that was just passed by the Assembly, and the Senate. And this is an overhaul, they say, of Chapter 125, which regulates alcohol licensing in the state. Most of these changes have to do with creating a new division in the Department of Revenue for enforcement purposes and changing the rules with respect to conflicts of interest between manufacturers, wholesalers, and retailers. None of that is really relevant to you on this committee, but I do want to point out some municipal-related proposals that are in there, so if it does pass, you are aware that these changes would be coming. We would probably have to make some changes to the ordinance as well to be consistent with the new state law. So one of the things that is being proposed is that wedding barns be licensed. Right now, they can't serve alcohol there, wedding barns are barns that are rented to members of the public for weddings, and what they want to do is to sell alcohol there, to serve alcohol there. There's really no way of licensing that in the current Chapter 125. So this new proposal would allow a no-sale event venue permit. So they would get a permit from the Department of Revenue. It would allow them to have up to 6 events a year, where they can buy the alcohol and then serve it to members of the party on the premise. Yes.
So that's if they're doing it internally and not having an outsourced licensee coming in?
Correct.
Okay, thank you.
The other thing that's being proposed with a Class C license, I mentioned in the first slide that right now it's only for restaurants that apply for a wine license. They would take away that requirement that it has to be a restaurant, so it would be to any premises, including bars. So this means that if the city is out of Class B licenses for liquor, right now an applicant would have to apply for a beer license and a wine license if they're a restaurant. So if we are out of Class B licenses, the bar or the tavern can now apply for a Class C license to serve wine and beer while they're waiting for a full Class B license. The other thing it would do is create an operator's license that's issued by the Department of Revenue, so it would apply statewide, so we would probably see less licenses for operators come through the city. It also allows retailers to pre-mix drinks and to serve it to the public, and then it would also allow producers to operate a full retail license sale of beer or liquor. So they would go through the application process, just like any other applicant, to sell within the city of Racine, and the municipality would have the same discretion to approve or deny the license. Those are some of the more relevant proposals. So that's really all I have. Are there any follow-up questions with that slide or anything else?
I guess I'm trying to grasp a little bit more about, so if they handle the operator's license, that's quite a bit that goes through the clerk's office now, currently, so that would be.
concurrent. So it could be issued from the municipality, and it could be issued from the Department of Revenue. So a person could apply to either one.
Oh.
That's what the problem is.
And
So
not
they-
one trumps the other. They might not like the city's process, so they could jump over it and then go to the state ultimately.
Mhm.
It looks like.
Or vice versa then.
Yes.
But it seems, I would presume that this, okay, so here's then a question, if the city has a more, strict process and the state does not, you can jump that, but if the vice versa, if the state has a more strict process, don't we ultimately have to then adhere to the state? The state usually trumps anything with finer detail.
So there's a section in chapter 125, that states that a municipality may impose any ordinance so long as it doesn't contradict with the state law. And my understanding of the bill and reading through it is it doesn't state what the requirements are or what goes into the granting of an operator's license by the Department of Revenue. That would probably be made at the administrative level. So all the state law would say is it can issue the license, and then the cities would say it can issue the license and impose certain conditions. So even if we had more conditions than what the department would have, it wouldn't contradict state law, not based on the wording of the statute. But it would certainly be a problem and a conflict. Maybe that's a good thing to bring to your state legislators, because I can foresee it creating a lot of issues.
Thank you.
Yes, Mr. Chair, do you have a question?
The only question I have is, do you have, other than our binder, could we have copies of all that, especially the new items that are coming forth?
The legislative update?
No, just in general, all the information you presented tonight.
Yes, so the slides that I just gave you, should have all of that information. It's just a really small print. So I can certainly send you the electronic version, and
That would be appreciated.
sure, I can send that to you.
We remember everything now, but when some of these issues come up, that's another story.
Yes, and I kind of speak pretty quickly, so it's a lot of information to take in, so I apologize if it's
No problem.
fast.
Thank you very much.
I just wanna say thank you to both of you. I thought
Yes,
this clarification was actually wonderful, so thank you both very much for your time. Thank you.
Thank you.
Yeah, thank you, and I think it's just a comment of someone who has sat through a couple due process hearings back when it was this committee's responsibility. When I found out, when I came back to being an alder, that it's no longer this committee's responsibility, what a relief, because exactly that conflict that Attorney Letney spoke of, you felt it during that time, so it was a good decision, whoever made that, to have that be a second, because it allows us to kind of stay focused on what we have to do and, not try to, hold both hats at the same time, so.
Thank you so much, everyone.
Thank you.
Thanks for your hard work.
Unless there's an objection, or are there any other serious questions or concerns? If not, we are officially adjourned.
Do we have to make a motion to adjourn, or was it? Because that wasn't part of the meeting, that was just.